because it offers up an encryption, end-to-end encryption.
And what are the most commonly used encrypted messaging apps?
It could be the one we're talking about here, which is the Messenger app. It could be WhatsApp. It could be Kik. It could be.
Everybody's ready? Okay. On the record, same counsel, same parties. No reason for the court to be doing additional appearances unless somebody tells me that there's a new appearance that I'm not yet aware of. Anybody need to do additional appearances that's come since the morning? You all moved seats a little bit, that's about it, what it appears. So, counsels, seems to me we've got, I agree with the parties, looks like you all want to split the time, so you've got 95 minutes each to utilize as you wish to utilize, and the reason why that's a little less than the standard time is actually to the end of the time, because I need to keep a little bit of time for questions, so, and other things that might pop up. So 95 minutes each, how you wish to utilize it. Does that meet the needs of counsel for the state?
Ready? Oh, sorry, Your Honor. Yes, Mike Van for Plaintiff, that meets our needs. Thank you.
Counsel for defense.
Your Honor, it does meet our needs. We understand the court's ruling from this morning, but I simply wanted to be clear for our record that MEDA does object to any taking of evidence until the resolution of the personal jurisdiction issue. I recognize the court's ruling, and we understand that the plan to move ahead with some evidentiary pieces today, but we did want to state our objection.
No worries, but remember, it's part of your opposition, so it gets taken in the whole bundle of preliminary injunction, right? So it's not anything different other than addressing the preliminary injunction in its entirety. Whether the court makes a ruling or not, we'll see. Stay tuned, let's see what everybody's got. Okay, appreciate it. So at this juncture, that means counsel for the state. Before you go on though, the reason why I also left you 95 minutes is we had a couple of objections to different things. So let me tell you the court's inclination, give you each a few moments to respond, and yes, this is part of your 95 minutes because you all decided to file all these papers, and so the court needs to address them. So with regards to the objection to inclination on MEDA's objection to the state's exhibits. The court's inclination is if it's 21 exhibits or whatever the exhibits that are not otherwise attached to pleadings that somehow were presented, after the conclusion of the pleading timeframe, that it would not be appropriate to be part of this preliminary injunction hearing. If either side says that there's a specific document that only came to its attention after the time of the close of all the pleadings by agreement of the parties. The reason why I'm saying that is because there was an agreement of the parties with a specific briefing schedule, okay? If there's some, quote, new document that popped up that was not otherwise available beforehand, then the court can address that when somebody wishes to present that, if that is the case. Otherwise, the court's inclination is that the objection should be sustained because the parties agreed to a specific briefing schedule, agreed to specific scope of how things would be done, and realistically, having exhibits that could have been presented as part of the briefing schedule and chose not to be submitted would not be appropriate to come because it would not allow everybody to prepare. With regards to MEDA's objection to motion to strike the declarations, the court, I hear you both inclinations, so you can get a few minutes to argue on both of them if you wish to. MEDA's motion to strike the declarations, the court's inclined to deny that without prejudice because realistically, those declarations are by witnesses that were previously provided in the motion, and to the extent those declarations provide responses to the arguments raised in the opposition, they would be appropriate, the same as how you deal with any other motion, whether it's an evidentiary basis or whether it's an argument basis. To the extent that there's somebody who's asserting that there's, quote, a new opinion, I'm going to reserve on that, and I'm going to let you bring that forward to the court to say what is the potential new opinion and why that would not have been had the opportunity to respond to such. That's the court's inclination on those two issues. So since they are MEDA's objections, same way we're going to do it, it's just one round each to give it, and then the court's going to tell you its final ruling. So, counsel, are you addressing both of them or different people? It doesn't matter, I'm just asking.
I'll be addressing both.
Okay, go ahead then, please, counsel.
And I'm going to start with the...
Saying your name and the party you represent. Thank you.
My name is David Sneed from Covington and Berlin. I represent MEDA in this proceeding.
Sure, go ahead.
I'll be addressing the two issues that the court has raised, including the objections to the exhibits that were provided by the state and the motion to strike the declarations that were appended to the reply brief from the state.
I realize the court's ruling would be also that it has some documents up their sleeve, either electronically read or sitting currently in a binder that was not attached to pleadings as well, right? Saying fair is fair, inclination. Go ahead, please.
Yes, Your Honor. in terms of the first issue, the point about what had been previously included, it's Meta's position that the limit and the meets and bounds of what the state should be able to use in this proceeding would be the materials that were actually attached to their prior pleadings related to the preliminary injunction motion. And so that universe, in fact, is only the 3 exhibits that they included attached to their reply brief. The larger universe of 54 that we were spoken about, 54 is the total number of meta documents that they disclosed in the last couple of days, and the 21 comes from the set of meta documents that were not identified in either the complaint or attached or referenced in any way, shape, or form in the briefing on the preliminary injunction. And so I think where it starts really is, it's our position that the only thing the state should be able to use in these proceedings as exhibits should be things that they actually attach to their PI briefing. And certainly the state shouldn't be able to use the 21 documents they just raised at the last minute. And so it sounds as if Your Honor has reviewed the materials. I won't belabor that point. I think you understand the point, and I can address any questions related to that. And we would also reserve the right to object to, on other grounds, as the state brings it up, during the course of their examination, if there's an exhibit that we have other objections on. I specifically want to raise the ceiling point that we talked about earlier today. We would maintain that ceiling, and to the extent that there's a lack of foundation or relevance or other issues with the exhibits that are in the universe that they attach to their pleadings, then we would address that at that point. On the second issue, which is the motion to strike the declarations, it's our position that each of the declarations should be struck. I understand from Your Honor that you would be open to allowing declarations that were responding to issues in the opposition, so long as it is a declarant that was previously disclosed. But in this case, we have a third declarant, Dr. Bolbeck, who was disclosed for the first time as a declaration appended to the reply brief itself. And so it would be our position in the first instance that there's really no basis, even with the case law that has been put forward about being able to respond with what's in opposition, to justify the use of a new declarant that is providing presumably or presumptively expert opinions to the court on issues that the state could have just as easily identified and been able to bring forward with regard to their motion. And the couple of things I wanted to flag on that last point is that the state has brought forward a few cases to justify all the declarations being able to be in the evidence. All of those cases are in the summary judgment context. None of the cases are in the context that we have before us today, which is the preliminary injunction context, where there is no burden shifting framework like you have in the summary judgment context in those cases. And in particular, those cases emphasize the point that if the things that were allowed, the declarations or evidence that was allowed, linked up with what was made originally in the first or opening motion. But in this case, in particular with the Goldbeck declaration, there's no ability to link it up because she was not a declarant at any point. And in some of the cases, including the Gilbert case that was cited in response to our motion by the state, in fact, 2 of the 5 exhibits that were put in issue were actually not allowed to move forward. They were excluded on the basis that we're offering today. And so the state really hasn't come forward with any basis to provide the court as to why Dr. Goldbeck should be able to present at the hearing or for her declaration to be in evidence at the hearing when there's really no way to link back her opinions to what was said in the original motion. And we disagree with the state in terms of all of them, but in particular with Dr. Goldbeck. In addition, I just wanted to raise that we have several challenges to Dr. Goldbeck's analysis and her presumably expert opinions that she's seeking to offer, and having only had a very short time, a week, to be able to address that, there's been no opportunity for Meta to be able to identify and make those arguments for the court, seek to exclude her on the basis of the nature of her opinions and the nature of her methodology, or seek out and identify a responsive or rebuttal declaration to the testimony that she's seeking to give today. And so for all those reasons, we would argue that there is no basis that the state has offered for Dr. Goldbeck or largely for any of the declarations to be able to be used. And I just want to address really briefly, the court mentioned that you were reserving regarding the prospect of identifying new opinions in the declarations that had declarations of motion. And we reserve the right to be able to object to the providing of new opinions from the declarants that were not in the declarations, or original declarations, as described in our motion papers.
So you're saying Dr. Goldbeck was, shall we say, came as a surprise for the first time in the reply, or you
That's
saying
correct,
that
Your Honor.
no discussion of those topics and those opinions being previously presented to you all? Question mark. Well, I suppose it was any of those opinions previously presented to defendants.
Well, I think we said no. These opinions that were offered by Dr. Goldbeck were never previously identified or provided to defendants. And so we don't think it's fair for her to be able to do so on the reply a week before the hearing and ask to testify in response to what's going on. My understanding is that the genesis of Dr. Goldbeck's opinions were really trying to respond to what was in the opposition brief that we put forward, as opposed to anything that they originally put forward in their motion papers. And so there was no chance for us to know that that's what we were going to expect.
But doesn't the state contend that you brought two new witnesses in your pleading papers in your opposition that previously hadn't been disclosed, and so they had to respond?
Well, in the preliminary injunction setting, they put forward their evidence and we had an opportunity, and they haven't challenged or moved to strike or another way, in any way, shape, or form, sought to exclude us from being able to address the issues that they raised in the preliminary injunction papers in response. And so I think there is a fundamental difference between the party that is the moving party having a motion to put forward their best evidence and to put forward what they're going to do. And let me just take a step back procedurally too. This is really not a second opportunity for the state to present a new declaration. Procedurally, what happened is we had a motion for a TRO/preliminary injunction where the state could have presented all of the evidence that they wanted to in the first instance. And then we filed the opposition on the shortened time, and they had an opportunity to file a reply to that. And they did so. They filed their reply. At the hearing, we agreed that we would handle the motion for a preliminary injunction later, and that both sides would be able to do an opposition and reply in the normal course. So what's happened here is they treated their first reply as a part of their motion, and we agreed to let them do that. But honestly, this is almost the third bite of the apple where they're getting an opportunity in somewhat sur reply, and at that point, they're trying to bring a new declaration of an expert witness to provide new opinions. I mean, the procedural scenario.
But wasn't that agreement by the parties on February 26th? I mean, that's really my inclination was based on what you all said on February 26th, right? This isn't a standard situation, motion, opposition, reply. This is you all, after having extensive conversations, right? We waited, more than 2 hours for you all to have all the conversations that you needed to have and your negotiations and what you needed to have, and then you came forward and put on the record the agreement between the parties. So isn't this different, and shouldn't the court look at it different in a standard motion, opposition, reply context?
Well, I think that the reason it's even more unfair to present something new is because of that very reason. I mean, the state came back and the agreement that we had was the state said we will stand on our motion and our reply, and we'll make that our motion for a PI so long as you let us do that together. That was the agreement. The state came and said that's what we're going to stand on. And the state agreed we would have an opposition, and we agreed they would have a reply. But at no point during our negotiations or afterwards or in court did we agree that it meant the state was going to have another bite at the apple to present new evidence. It's one thing in reply to present new arguments, to present arguments that respond to an opposition point that was made that you weren't expecting. It's quite another to try to fill in a gap that was left by your own motion, and in this instance, your own motion and reply brief. Try to fill in a gap that was left after having seen what is essentially a second opposition from Meta in this case. And so I think that the distinction in this case would only inure to make it more likely that it's unfair for the declaration to be able to stand here today.
And your two witnesses that were, your declarants, right? They're non-company witnesses. Are they, they're only company witnesses or they're non-company witnesses? Because I thought one was a non-company witness.
Our two declarants are company witnesses. We have not sought to introduce any expert testimony or had an opportunity to introduce any expert testimony. And it would be the first, It's the first we learned of experts being a part of the motion for a preliminary injunction at the time of the reply.
Appreciate it, thank you so much. Who's responding to this one? Go ahead, counsel.
Attorney Michael Gayan for the state. I'll be addressing Meta's objection to allegedly new exhibits, and Mr. Springmeyer will be addressing the motion to strike items attached with our reply. So the objection, I want to make a bit of a record here because we haven't had a chance to respond in writing on this one. This is the one I believe that was filed last night. Their objection on the new exhibits fails for any of the
Let
number
me
of
stop
reasons.
you for one quick
Sure.
second, and make sure you don't have an issue. I am cognizant of the 9:28 PM document that I got,
That's
is the
right.
one you're addressing, right?
That's the one. And for
Now, the
whatever
reason why I
reason,
was moving forward today is because you all vociferously right before the lunch break said you wanted to move forward today. Part of my reasoning on why I thought this could go to April 16th, right, is gave everyone an opportunity to do their oppositions to various documents, et cetera, et cetera. So if you're saying that you need extra time to actually respond, then please let this court know, right?
no, I'm just,
Doing consistent with what you all told before the lunch break, that you did want to move forward with a preliminary injunction, which means by definition I have to address these issues. Go ahead.
I do want to go forward. I only made the comment or pointed that out because my comments might be longer than if we had already had something in writing and the court had an opportunity to review it.
No worries.
So we certainly do want to proceed. Okay, there's a number of problems. Meta's objection, first of all, cites no rule or case that says at a preliminary injunction hearing, parties are, first of all, obligated to disclose things in a certain way or by a certain time. The court certainly didn't set a deadline. After being here for hours on February 26th, neither side asked to set such a deadline. So there's no legal authority that they cite at all. This is not discovery. We are before the motion to dismiss on a preliminary injunction hearing. We had a TRO set on February 26th on short notice where there was evidence, and they would have had to respond in 6 days and show up. And the state agreed to carry that over as an accommodation. So here we are today. There's no legal authority, no rule, no case, no nothing that they cite. That's the first point. Second point, the parties met and conferred on Friday, March 15th, last Friday. We spoke and we talked about hearing logistics, including exhibits, and we agreed that each side would disclose their anticipated exhibits by 10 a.m. yesterday. And we did that. So to say that we should be precluded from using exhibits that we timely disclosed under the agreement of the parties is absurd. And by the way, to show the absurdity of Meta's objection, I've got their exhibit binder here that Holo put together. Meta's exhibit list that they gave us yesterday had 6 new documents on it as well, some of which we had never seen before at all. So Meta's objection is completely inconsistent with its own conduct and its agreements with the state. So I just don't even understand why we have an evidentiary hearing and Meta wants to keep the evidence that this court hears to the handful of documents identified in the complaint. These are all, the 21 documents they're complaining about are all Meta documents. I checked with the Attorney General's office. They said Meta started producing these documents to the state in July of 2022 and produced additional ones as recently as October 2023. Presumably, Meta's counsel reviewed these documents before they produced them. These are documents in Meta's possession that the state would like to use with witnesses here today. And Meta has had notice of that since the agreed upon deadline for the parties to exchange their witness list. Now, Mr. Sneed asked that we narrow down our exhibit list because it initially started a little bit longer, and they brought that up in their objection. Well, the reason it was longer is because Meta wouldn't tell us whether they were bringing either of their witnesses. And so we did not know what this hearing would look like until yesterday, early afternoon, I believe it was. So we were doing the best with the information we had, and Meta kept that card until the end, and so we had to deal with that. But we did pare down the exhibit list. We have 64 total. The majority are identified in the complaint or attached to the state's briefing. and there's a handful of additional meta source documents that the state would like to use. One other evidentiary point I would like to make is that even if the court does not admit these supposedly new documents, the state should at least be able to use them for impeachment or to refresh recollection. There's no reason they should be precluded from being used for all purposes here today, and I don't even know that the objection asked for that relief. Anyways, Your Honor,
You're saying that there was a meeting yesterday that's not in this objection provided to the court?
there was
On exhibits?
a
I'm rereading it right now because you can appreciate my inclination was based on the information provided to the court, but I don't see anywhere in here.
Yeah, that's a good point, Your Honor. The March 15th meet and confer on Friday, March 15th. It was me, Randall Jones, I believe Don Springmeyer was there, and then I had co-counsel Mr. Slade, Mr. McMath, and Mr. Carlson listening in. But Randall and I primarily led the discussion with Mr. Sneed, and we went through witnesses. We discussed witnesses, exhibits, and sharing of time, and a lot of the other things that ended up on the to-do list that you were handed this morning. And we agreed at the time that each side would disclose their proposed exhibits 24 hours before the hearing was set to start. So yesterday at 10 a.m., and we complied with that. We even sent our exhibit list earlier, and then pared it down after we knew who was showing up. So,
Was there any agreement from your perception that the quote lists of exhibits that would be provided by the 10 a.m. was limited to documents either attached to the complaint and all the pleadings, just the pleadings, or any other qualifier?
yeah, Meta did raise that objection. I don't want to mislead the court. Meta raised that objection. They thought it should just be, now I don't actually recall exactly their position. I'll let them state it, but they weren't necessarily agreeing that we could disclose additional documents. And Mr. Jones, I recall, commented on how many preliminary injunction hearings he's done, as he's wont to do, and mentioned that he's not aware of such limitations, and so we were not going to agree to be limited in such a way. And that really it was just about fair notice of what you plan to use. And we agreed fair notice was 24 hours, and that's how we proceeded with things. 20 documents that originated from Meta is not a lot, and Meta itself disclosed 6 documents that I didn't even have. And I had to hurry once I saw them on the list and try to chase them down. I asked Mr. Sneed to send them. They got hung up in my spam. So we've only had those for less than 24 hours, and we're ready to proceed. So it's just inconsistent that Meta's identifying 6 documents that were never provided to the state until yesterday afternoon, but they want to exclude their own documents that the state
Yesterday
identified.
afternoon by your 10 a.m. agreed upon deadline.
Well, they identified them, but they did not provide them to us by 10 a.m., and I did not have them. I had co-counsel helping chase some down, others we had to get direct from Mr. Sneed, and I did eventually get them in the afternoon.
Okay, thank you. Well, I originally said 1 round each, but I am going to have to ask counsel for Meta. So I've just reread that yet again, last night's document, which we appreciate. Did not get a courtesy copy until I was already on the bench, right? With regards to last night's 9:25 p.m. filing, pure breach of EDCR, right? The only reason why I was hearing it today is because it directly impacted the preliminary injunction. So I guess the first question is they would have to address your objection or some time when the EDCR, and it just gets disregarded and waived. But going to the second step, I'm going to ask you my second step question. Why does the brief not say that there was any meet and confer between the parties on the previous Friday and there was any agreement between the parties? Because when you read that brief, it looks like that the state of Nevada just basically, I think your words were blindsided and other things. You can, okay. And because of the state's late-breaking disclosure, right, just one phrase, the 11th hour would be prejudicial, but there's nothing about any Friday discussion in which reportedly you all agreed that exhibit list would be exchanged at 10 a.m. Was there such agreement, or are you saying that the state's incorrect in their assertions to the court?
I'm saying there was no agreement that either party would be able to disclose and use documents that were not a part of the record for the preliminary injunction motion, particularly the state, wouldn't be able to come and move forward. So
Counsel.
there was
you
a
don't answer part of my
conversation.
question. Yeah.
Yes,
Please
there was a
answer-
conversation.
Please answer the substance of the big part of it, thank you.
Yes. There was a conversation where the parties discussed about when we would disclose documents that were going to be used. At that conversation, Meta made clear that we were not going to agree to the state disclosing any and every document that had been ever produced by Meta in the case, in the pre-suit investigation. We made clear that at that point, and we followed up on that point before the state did its exhibit disclosure as well, so that it was abundantly clear that there was no agreement the state could disclose things that were not a part of the record that was currently in the case.
Why just a brief, not have any statement about saying meet and confer under the duty of candor to the court to set forth that Meta and the state had agreed upon a 10 a.m. or some other time deadline to provide a list of exhibits, and these exhibits were part of that exhibit list that was provided in accordance with that. Unless it's in invisible ink, I don't see it.
Your
And that
Honor,
is concerned to the court, because you can appreciate the court's inclination. I took you all at your word, okay, that was the basis. I'm now hearing today in open court, right, that not only was this document not filed till 9:25 p.m. with no courtesy copy to the court, right, for it to be able to review, but the bigger issue is it somehow is devoid of anything about a discussion between the parties, that there was agreed upon disclosure deadline, so statements such as 11th hour, right, would be so prejudicial, when it appears that there was maybe not an agreement on the actual exhibits themselves, but at least the timing of the exhibits was not, quote, 11th hour. That is a concern to the court. Candor to the court is a very big concern to the court, counsel. Why is it not in the brief at all?
Your Honor, candor is extremely important to both Meta and to me as an attorney working on this matter. We take it with the utmost importance. In retrospect, we should have been clear that there had been a discussion.
Clear, it's not mentioned anywhere. It's not a matter of vague. It's not in a footnote, it's nowhere. Right?
Yes, Your Honor.
I'm sorry, Ms. Peterson's name on this is under Rule 11.
Your Honor,
I'm happy to respond, Your Honor. I'll be candid, I was on call on Friday. This issue about the timing is not material to the objection that we made.
It's material to the language that implies to this court that these were 11th-hour disclosures that nobody had any notice of when you all had a conversation.
The 11th hour disclosure was the fact that we had not seen these documents at all. Our conversation on Friday was specifically about what was in the record, and we asked for a time about that, and we got new documents that we had never seen. So I do
Are they
apologize.
meta documents? They're not
Well,
meta documents?
They're not in the record in this case, Your Honor.
Right, but when you say that you haven't seen them, counsel, you can appreciate, that's why I had to ask the question, if they're your own client's documents. That right would go to whether you've seen them or not.
I have never been in a case where I have to guess what my opposing counsel is going to bring to court to prove their case. I saw the complaint, I saw the exhibits, I saw their motion, I saw their declaration, and they gave new ones. And I just want to be clear, Your
Did you
Honor.
all also give new ones in your binders? The 6 documents that Mr. Gayan referenced?
And again, we did not have an agreement about that. We disputed that particular issue.
then
So I
you
just
all
want to be
filed
clear
an
what
objection, but
the
counsel, you
meet and
understand-
confer was about.
But let me be clear what the court's question was, right? The court's question is, in reading this brief, it does not seem to accurately reflect all the facts. Does not seem to reflect the fact that there was, or you all might have disputed what exhibits could be presented, that there was an agreement between the parties to present an exhibit list on or about 10 a.m. the day before. Now, whether you all choose to do it the day before, you've had since February 26th to have your meeting confirmed, but that's a different issue. But you created your own issue. I don't see an objection from the state that's saying we should strike Metas because they provided it the day before. Instead, what I do see is a 9 p.m., right, pleading that says, okay, what is that? First off, they may contain information regarding Meta's non-public policy, so you kind of acknowledge the Meta's, but for late-breaking disclosures, et cetera. So it appears to this court when reading it is that only the state all of a sudden provided new documents, not Meta, and that there wasn't any discussion about providing documents the day before the hearing. You can appreciate those are key aspects for a court in reviewing anything to look at, because honestly, you all came in open court, you had a briefing schedule, you had certain agreements that were made on the record, EDCR 7.50, and then subsequently there are some stipulations signed by the court after you provided them to the court. Those were the parameters. New things were not within the parameters, other than you all know in the ordinary course of litigation, sometimes new things come up that you have to address that are specific and unique. There's just nowhere in this brief that says we had a meet and confer, and look, we agreed to certain X.
That's fair.
Okay, that's
fair, and I understand the court's comments on this. I want you to know that I did not think that was material, because the issue was about the new documents. That was the issue. So, no, I didn't go through and say everything that we agreed in the meet and confer on Friday. I
It
didn't
also
do
doesn't
that.
say, and Meta also provided new documents to the state, right? It doesn't say that either.
To be clear, on that point,
Are we doing back and forth here? Can I at least get an answer by the same counsel that asked the question of?
That is true, Your Honor, that is true.
whatever, we weren't given notice at all that there was a challenge to new documents. I believe the new documents they're referring to are in response to Dr. Bolbeck's declaration that we needed to provisionally provide notice of before this hearing so as to be able to use them in case the court did not agree with us about the declaration of Dr. Bolbeck. So in terms of new documents.
But you don't have that anywhere in your brief, counsel, and that's where the court's stressing the concern, right? I understand that you're saying, look, we needed to do X because of Y, right? But the brief doesn't say that. The brief doesn't say me that information. It doesn't say, look, we agreed to exchange documents here, but instead they did these documents. And by the way, court, just as a heads up, in fairness, we also disclosed new documents, but we needed to do it because of Dr. Goldbeck or some other reason, right? The brief on its face does not address the
You're correct, Your
at
Honor.
all, does not address the fact that Meta brought documents as well. It presents to this court in a pleading one version of events that is not fully accurate. That is a concern, and I'm sure this is the last time we have to address that issue. Feel free to go to the substance. Go ahead, please.
On the point, fundamentally, we maintain that what is in this brief reflects what we believe were the material issues that were there. But this brief was filed within hours of receiving the final exhibit list, an attempt to kind of identify and raise the issue that we had found with what the state had done.
But didn't
In
we
terms
all
of this
decide when you wanted to do these exhibit lists? Did anything preclude the parties from meeting February 26th, February 27th, February 28th, February 29th, right? Any date before the very Friday before you have a very large hearing, right? On the Wednesday, you all decided your date which we're gonna do your exhibit list.
That's correct, Your Honor, but at the very first time we had the interaction with the state's counsel, we made clear that we were not in agreement about the prospect of putting new evidence into this record. And we maintained that throughout the process, and as soon as that issue became right, we addressed it directly, which is filed something immediately identifying these additional documents.
Springmeyer, you're gonna address the other issue, and then the court's gonna make some noise. Go ahead, please.
Thank you, Your Honor. Don Springmeyer for the state. With respect to the state's position on the motion to strike the declarations, our position is very simple. Our second set of declarations were entirely framed as replies to new material that Meta put up in its opposition. I think it sounds like Meta is conceding as to the two, the Defonseca and the other investigators' declarations that that's true. So they mainly seem to be focusing on Dr. Goldbeck. But we provided the court with a table where we go piece by piece through what they said and what the declaration of Dr. Goldbeck responded. And that's the purpose of it. And entirely aside from that, everybody's here to testify today. How much difference does it make what was in the declaration when the person is gonna be on the stand, they can be examined, they can be cross-examined.
But aren't they objecting to Dr. Goldbeck going onto the stand? Isn't that the issue as well, right? Is that the information, right? Dr. Goldbeck does not have firsthand information, correct? It's a third party reviewing documents, presenting potentially what you're saying is a hallmark-based expert opinion, correct? Dr. Goldbeck's not an employee of the state, does not have direct evidence with regards to what does or does not happen with subpoenas and the probable causes that judges analyze, by the way, not people who submit those warrants, or pen registers or CDLs, et cetera. That being said, isn't that their distinction, is that you're trying to provide an expert without there being an expert report under the NRCP and all the requirements and trying to put it in a preliminary injunction hearing?
None of that is required for a preliminary injunction hearing. That's discovery. We're allowed to bring any witness we think would be helpful to the court. There's no prohibition against an expert testifying in a preliminary injunction hearing. And I agree, she is not an employee of the state, and she's offering expert witness opinions, but they bear directly on the presentations by Meta, which are mostly errors of omission and misrepresentations, which cannot be contradicted by any employee of the state directly. So she's very useful in examining what Meta is trying to talk Your Honor into.
But doesn't Hallmark and other cases set forth a procedure by which you have to do, the NRCP has a specific procedure that you have to disclose an expert, and the expert specifically has to do a report, and those changes even after 2019, when we modified the NRCP, were done consistently there too, right? And the only difference really was with the medical provider in certain contexts, a treater.
I believe only in the context of discovery, Your Honor. I don't know of any case law or any comment to the rule even that says that all has to happen in advance of a preliminary injunction hearing.
Do you have anything that supports that you can have it as part of a preliminary injunction hearing, right? Because you're the one that's asking the witness to be able to participate. It's a distinction, right, if they're recipient witnesses, because they would be called. There's a separate set of rules with regards to individuals that are not recipient witnesses, right? And there's no carve-out that says this only applies after discovery has commenced, right? There's specific report requirements to give the other side an opportunity to address whether the person's qualified or not under Hallmark, and then to address all the different factors with regards to their testimony as well, right? Because sometimes the court doesn't even let a witness testify if there's potentially a challenge through a motion limited or other type of motion practice that someone may not meet the Hallmark qualifications, not be relevant to the case, and a variety of other reasons that the court has given.
That's true, but there's no authority the other way either.
But you want to bring her, don't you have the burden to say it's your authority that you can bring her here today?
Well, when there's no authority either way, I think we fall back on what is useful to the court in making its decision. And if they want to attack her expertise or her credibility, here she is on the witness stand, and they can do it.
Did you even provide them a CV or anything? Anything that would show her background experience and the basis of her opinions? And how short of notice did they get that? They got it attached to the reply, right?
I'm not sure about the CV. We have it here, but I'm not sure we provided it at the time.
Okay, go ahead, please. Let you finish. Sorry. Okay, well, the nice wonderful thing about excellent attorneys who try and address things in art. Here's what the court's ruling is going to be. I'm going to modify in part. Dr. Goldberg is not going to testify. I'm not going to take into account the declaration. It's inappropriate. The rules, NRCP has a specific provision with regards to experts, and there's a whole reason with that Hallmark, the Nevada Supreme Court. There's not a distinction that somehow it only applies post-discovery, because the whole concept is you have to give the other side an opportunity to not only know if the potential expert has the qualifications, i.e. a Hallmark analysis, you have to give them the CV, you have to give them the materials, the report, so they can evaluate everything, because there's a very big distinction between a recipient witness and an expert. There is nothing that sets forth that you can, on a hearing in which people have the appropriate time to fully be prepared. I don't say due process issue, but somehow within a reply for the first time can throw in somebody that you want to have give third-party expert opinions when that would be brand new opinions for purposes of this case. And so therefore, Dr. Goldberg's declaration will not be considered, and cannot testify, and nobody's presented this court any case law or rule that somehow would allow her to do so. Just the general concept of, well, we can bring what we want for a preliminary injunction is not the rule in a third-party case. Excuse me, a third-party witness, i.e. someone who wants to testify as an expert, because of all those factors that are taken into account in the concept of an expert. And I will parallel it to if a person was not disclosed timely in the NRCP and tries to testify for the first time at trial. The Nevada Supreme Court says it cannot happen because of the fairness concept. It's not the timing or the type of motion or that it's a trial proceeding before the court. It's the fact that you have to give the other side the opportunity to evaluate the CV, to evaluate the histories, to evaluate all the factors under Hallmark. And there's no way this court can even do a Hallmark analysis to see if Dr. Goldbeck can even potentially testify, because no one's provided this court the information that would be appropriate for this court in order to allow her to testify, and that's clearly under the Nevada Supreme Court under Hallmark, and so therefore she would not be able to testify. That's the ruling with regards to the, I'm adopting my inclination with regards to the other two declarants who gave supplemental information with regards to their reply. Now let's go back to the exhibits. Well, you all heard what you agreed to. You agreed to provide exhibit lists. They were on that exhibit list that was 10 a.m. The court is going to address, the court's not going to say it's going to, quote, be an exhibit that's admissible. I'm going to deal with that. I'm going to deal with any objections, but I'm not going to preclude documents that were provided by the agreement of the parties when you all chose to do your meet and confer, when you chose to do your meet and confer. Okay, if you choose to do it on the Friday before today's hearing, and you agree that 10 a.m. you're going to provide an exhibit list, and each party gets to reserve their objections, you get to reserve your objections with regards to each individualized exhibit, just as you would otherwise. But I'm not going to preclude it as being untimely or a 11th hour or a late-breaking disclosure when the timing of the disclosures were exactly what the parties agreed to. It may not be the body and the content of where I do not see that there's any unfair prejudice to either side, because realistically, I appreciate Counsel for Med is now going to tell me, well, their 6 is no longer relevant because of my ruling on Dr. Goldbeck, and really just take my 2 rulings in flip order and remove them. But the concept is the same. It's the concept of fairness. When parties come to an agreement, counsels come to an agreement, right? Then you got to stick by that agreement. If the agreement is, guess what, you're going to present your exhibit list by a particular date, then all those exhibits are fair game. And when I use the term exhibits right now, I'm not saying admitted exhibits. I'm taking them as potential exhibits, subject to any other objections anyone wishes to raise during the course of today's hearing. It is so ordered. So, and you can appreciate the court's inclination is a little bit different than my ultimate ruling on that, is because I wasn't given all the information initially. So maybe I should be doing a little information down the road, but go ahead. So that's the court's ruling. So now, are we getting to substance of the actual preliminary injunction hearing? Is there another matter? Mr. Jones, I see you standing. Is there another matter? Go ahead, please.
No, it's just in relation to your ruling, Your Honor, and I understand your rule. I'm not trying to talk you out of it. Just for the record, at some point, the appropriate time, assuming there is an appropriate time, and time is obviously passing, we have limited time, but we would like to make an offer of proof with respect to Dr. Goldbeck. And so at least I wanted to put that on the record. We would like to make that offer of proof, assuming the court would allow it at some point during the process.
If you want to use it within your 95 minutes, you can feel free to do so, because that's a proper procedural aspect, okay?
Thank you, Your Honor.
So that means the 95-minute clock is starting now, so you can appreciate counsel for plaintiff. Feel free to proceed with regards to your beginning of what you would like to proceed to as your motion for preliminary injunction. Are you doing arguments? Are you doing witnesses? What are you doing first?
Your Honor, we're going to, Michael Gayan for the state, we're going to start with witnesses, and Mr. Carlson's going to start with that. But before we get started, I did want to make just a comment that, I would ask Meta's counsel to let us know whether they intend to call one or both of their witnesses. If they don't, we may need to call their witnesses before we rest. What I don't want to have happen is, based on the court's ruling, maybe they don't put up one or both witnesses that they've brought, and then I can't use any of the new documents you just said I could use. So, and if they can't commit to that right now, then we'll proceed accordingly and do what we have to do.
Okay. Councilor Bennett, do you wish to answer Mr. Gayan's question, or?
Yes, Your Honor,
Stay tuned. Go ahead.
we do intend to present both of our witnesses live today.
Okay.
Okay,
Two
then,
questions.
yeah, thank you, counsel. So then we won't call anybody out of order, and I'll save questioning for those witnesses for cross-examination. So without further ado, Mr. Carlson is going to start with the state's first witness.
I'll give you a second to get up to the podium and then set forth your first witnesses. And do any of these witnesses need any accommodations or all of them fine to go to the stand?
Your Honor, I believe that both witnesses are fine to go to the stand.
Okay, great.
Bill Carlson for the state. Your Honor, first thing I'd like to note is that the state would like to invoke the exclusionary rule as to witnesses.
Okay, for both sides. Now,
Yes, Your Honor.
is there any objection from Meta Platforms?
I believe the state invokes the rule, we have to abide by it. So we will look at that, Your Honor. That's their position.
Okay, so then anybody who would, and you all know with your respective sides of your room, who that's going to apply to, right?
It would be two witnesses, Your Honor, on our side.
Right, and on your side?
Yes, Your Honor, we have two witnesses left to present then, I guess, and so one of our witnesses will have to step out first.
Well, also Dr. Goldbeck as well, right? Because if we're trying to do an offer of proof, then she would need to leave as well.
May I confer with counsel?
Oh, yeah. Go ahead. Your Honor, I think the court's already acknowledged that, and actually more importantly, that is acknowledged that she's an expert witness. And therefore, she is not required to be excluded from the courtroom during testimony.
Let me hear if Meta has acknowledged that fact or just used the term.
We don't agree there, Your Honor. If the rule is invoked, it's invoked across all witnesses.
Well, actually, a little bit different than Nevada aspect of it. Okay, so,
And Your Honor, you already raised, the reason that you're not allowing Dr. Goldbeck to testify is because Hallmark has specific rules about expert witnesses. They haven't been disclosed. She hasn't been disclosed as an expert in that sense. She's not, but she is now known as a potential witness. She should be excluded.
Well, Your Honor, if she's not going to be allowed to testify, there's no reason to exclude her.
Are you agreeing to exclude her through the rest of the case?
Absolutely not. I have no obligation to do so. You can't cite me a rule that says I do.
okay, here's what I've got. You all have invoked the exclusionary rule. The exclusionary rule would be with regards to potential witnesses. This court doesn't know at this juncture, right? Because you're going to give an offer of proof. I'm not sure what you all may be arguing after your offer of proof, that maybe the court has to reconsider its ruling or not. I can't read your mind. I keep pointing to my lovely crystal ball, which is absolutely wonderful and fantastic gift from a former extern. But that being said, it does not foretell the future. So at this juncture, Dr. Goldbeck is going to also be excluded because at this juncture, she's not been qualified as an expert, so she would not get the benefits of being an expert. And since Meta has clarified their position that part of their issues are that she does not fall within the expert categories, I need to preclude her because otherwise you said you later on going to do an offer of proof that might have the court evaluate its ruling. And so you would be precluding her from testifying if you're asking to do that offer of proof and potentially, depending if your offer of proof is, I don't know what your offer of proof is going to be. Is it going to be just a straight offer of proof as to what she could have testified to? Is it going to be an offer of proof and also asking the court to reconsider? Realistically, in the abundance of caution, and appropriately, I'm sure she's going to join the hallway with the other two witnesses.
I understand it, just for the record, and so, because I understand, I think I understand your ruling. We certainly understand she will then be excused by the court. For the record, I would object on additional ground. Not only have they denied that she's an expert witness, or suggested that she doesn't qualify in the Hallmark, or at least the court has, and therefore is not an expert witness at this time. The second reason is because the court's knowledge, and Meta brought this up, she's not a recipient witness. Therefore, since she's not a recipient witness right now, theoretically, she's a member of the public and she can sit in there. If she's not a recipient witness, unless they want to tell me otherwise, we'll represent the court. As far as I know, she's not a recipient witness to any of the issues that are being raised today in this court. So, for the record, we would object to her being excused, and I don't think there's any authority, statutory or case law, that supports the proposition that a consultant, let alone a expert witness under Rule 26 and 16.1, can be excluded from the courtroom during the testimony at a public hearing, whether it be a trial or a preliminary injunction. So for the record, we would ask the court reconsider its ruling and it should be allowed to stay. With that said, I'm just making my record.
I hear what you're saying, counsel. Once again, remember, I cannot read your mind to know whether your offer of proof is going to include any motion to reconsider the court's prior ruling, or whether or not this preliminary injunction hearing hopefully will be concluded today, but it may not at the rate that it's currently going, right? No one can say it's breakneck speed. That being said, so you understand that there's potential ramifications that may happen, which is why this court was saying that she should be excused if she's going to be a potential witness.
But just so you know, Your Honor, we would not offer her, I believe, we have no intention of ever offering her at any time as a recipient witness. We would be offering her ever as an expert witness. And I would just make the point on the record that should the court reconsider its decision after our offer of proof and determine that she was properly designated as an expert witness, then she would be allowed to have stayed in the hearing. But I just made it a record.
No. I appreciate what you're saying. Okay, so
Thank you.
linguistically, let's circle that one back. Counsel, I'm going to give you the last word on this before the court makes a determination.
Well, I was gonna ask Mr. Jones if he was suggesting that we're only talking about the exclusionary rule with witnesses we've said are testifying today. Because I think there's probably other witnesses from Meta who might be witnesses in this case. I haven't.
And they get to stay here, folks, fair is fair. So if you have potential witnesses, and you're not objecting to their potential witness down in the future, not for purpose of the preliminary injunction hearing to be here, then your witnesses, who may be potential witnesses down the road, would be able to remain.
Well, the difference would be that they have already made an offer of proof as to this potential witness that we do want excluded.
I haven't heard the offer of proof yet. Mr.
Right,
Jones said
right,
he's going to.
and so they're not, so as to, I'm only talking about Dr. Goldbeck. I do think she should be part of the exclusionary rule. She should be out in the hallway.
And let's walk this through, okay? Preliminary injunction only, right? With both sides saying that there might be people sitting currently in the courtroom, maybe recipient witnesses, that you may wish to testify later at some potential proceeding. In no way advance ruling on your motion to dismiss or any other pleadings that have not yet become before me or might be coming before me while I'm sitting here on the bench, right? So if there is going to be future hearings, there may be witness testimony. I believe you stated to the court that someone who's currently sitting in the courtroom other than the
I'm
two
simply not
individuals
able
may
to
or may not.
say yes or no on that.
We'll truncate this, so we do want to proceed. So Dr. Goldbeck is going to leave. They can do whatever they want to do, and we'll all see where the chips fall in the future. But we would like to proceed because, as you well noted, time is passing.
But let me be, then I wasn't going to make, I was revisiting the issue because Ms. Peterson said that she has other people who might be testifying down the road. So I told you fair is fair. Goldbeck can stay if their potential witnesses are going to stay. From this court's perspective, it's fair and everybody. It's very, very clear who's leaving, right? Two Meta people who may be testifying today, and one of the state's witnesses maybe today. If there's other people sitting in the courtroom and you both want to say, look, there's people who may be testifying down the road, we prefer them to stay in here for this hearing, then the court's going to be fine with it. If you're both saying, guess what? There's the only person that's potentially sitting in this courtroom who's ever going to testify in a future proceeding is Dr. Goldbeck, which may or may not, then I potentially have a different viewpoint. I have to hear what Meta's viewpoint is. But as soon as they told me that they have people that might testify down the road, then that changes the scenario, right? That is fair, everybody can stay.
No, I appreciate that. I just was trying to make the point that I probably caused more delay now than anybody. So I wanted to just try to move it on so we could get started. And again, Dr. Goldbeck will vacate the courtroom and they can do what they're going to do. And we'd like to proceed.
Thank you, Your Honor.
Okay. And you understand there's really a non-issue for the future, right? Since anyone can review the transcript and review the video. And so it really is for purposes of today's hearings, there's really a non-issue, right? As far as today's modern technology aspect, whether they're sitting here or whether they're listening to something down the road. I only point that out for the practicality aspect, but fine. Whoever needs to leave, please leave, subject to the exclusionary rule being invoked. Okay, counsel, would you like to call your first witness?
Thank you, Your Honor. Before I do that, would it be possible to ask them to identify the names of any potential future meta witnesses who are in the courtroom today?
We don't have any such needs today.
Thank you. Your Honor, the state
Can we
would
get to
call,
the substance of today's hearing, the preliminary injunction? Go ahead, please.
absolutely, Your Honor, the state would call Anthony Gonzalez.
Okay. Okay, witness.
Pleasure to stand. Watch your step closer. Thank you. Once you're up there, please remain standing, face the court card, and raise your right hand.
You do solemnly swear or affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under pain and penalty of perjury? Can you please state and spell your name for the record?
Sure, Anthony Gonzalez, Anthony, Thomas Spelling, Gonzalez, Gomez.
Feel free to proceed, counsel.
Thank you, Your Honor. Mr. Gonzalez, thank you for coming today. You identified yourself, spelled your name. Could you please tell the court what you do for a living?
Sure, I am a criminal investigator for the Attorney General's office, currently assigned to the Human Trafficking Child Exploitation Unit. And I also, that's where I'm assigned to permanently.
How long have you been doing that?
I've been assigned, I've been working at the Attorney General's office for 2 years now, a little over 2 years, I should say. And I've been assigned to this specific unit in the past, since the end of May last year.
And you have received training both as a law enforcement officer and specific training to inform your duties as they currently are, is that correct?
That is correct.
Would you maybe just briefly touch on a couple of those trainings, very briefly?
Sure, essentially I have to go through a police academy to become certified peace officer in the state of Nevada. I also have received my advanced training certificate, which means I've hit X amount of criteria to obtain that certificate. I've also been trained in how to conduct internet investigation, as I say, or investigations that entail some sort of electronic devices, how to serve a search warrant, how to do interview interrogation. So those are just kind of just a brief touch on what my trainings have encompassed.
Thank you. And what are your duties as an investigator, briefly again?
Very brief. I get an investigation. It's my job to solve that investigation. So those administrative duties may entail serving a subpoena, serving a search warrant, any kind of type of legal processes affecting an arrest, various things of those natures.
What percentage of your duties would you say involve child sexual exploitation crimes?
Right now, since that's my unit, that's almost 100% of what I do daily.
And are there other officers that are involved with, I think you said it was ICAC, are there other officers who are involved with ICAC throughout the state?
That's correct. So I am part of a larger, I guess we could call it task force, the ICAC, Internet Crimes Against Children Task Force here in Southern Nevada. And they are also part of, they are also tasked with, I guess, investigating crimes against children, and those agencies that make those up are, various around the state. So everybody basically in Las Vegas has some sort of stake in that task force.
Thank you. So in your experience as an investigator, is there a direct connection between the crimes that you investigate and the internet?
There is. That is hence in the name, Internet Crimes Against Children. So everything that, when we get a tip or saying, hey, this is something we need to investigate, it involves a component of an internet, electronic device, and hence a child involved.
Social media platforms?
Yes, social media platforms.
Do you specifically, in your experience, see those crimes starting on platforms owned by Meta?
Yes.
And do you see people who participate in those crimes using Meta's messenger platform?
Yes.
Objective leading, Your Honor.
Sustained.
You restate the question. Is there a particular platform from Meta that you see those particular individuals using?
Sure. In my experience from the cyber tips that we've acquired and kind of the lead of how investigations start, they have been flagged through a messaging platform that Meta uses. I guess it would be their direct messaging feature.
And is that platform called Messenger?
It is the app within that's associated with the direct message feature for each account, either to Facebook or Instagram, for instance.
In your experience, is there a particular feature of the Messenger platform that they like to use?
In general, yes. I'm going to call them I guess, perpetrators, or we'll just say suspects in these cases, because again, all of them have gone through the court process, so they are suspects allegedly. They prefer the encryption aspect of these, of this particular platform, encrypted end-to-end encryption, where essentially it would make it invisible, I would say, to law enforcement or anybody else to essentially raise the, red flag and say, hey, there's something going on here. And just the nature of these investigations, they prefer that method.
Okay, and I want to be clear here. They prefer the end-to-end encryption because it hides their crimes? Is that what you're saying?
Object is leading, Your Honor.
I'm asking a clarifying question. I'm sorry. Thank you. Why are perpetrators of these crimes using meta platforms specifically?
The nature of these crimes, these individuals that we investigate, they simply don't want to get caught. They are using this, it gives them a shield from their activity from anybody that is of concern, and it gives them a sense of an anonymous nature to what they're doing, so where they don't want anybody to know, so that's why they use it.
Do the perpetrators also use the other meta platforms like Facebook and Instagram?
Yes, they're, because it's connected and it has a wide range of access to essentially everybody. I mean, Meta's a big platform. They have access to almost everybody that I know in my, world and investigation. Everybody has a Instagram. Mostly everybody has a Facebook now, and it's connected. It connects everybody in the world, so they have access to millions of people, specifically even in Nevada, that they may not know.
What are these perpetrators searching for on those larger or those more general platforms like Facebook and Instagram?
They're looking for victims. In my experience, they are targeting these specific accounts, or just, for lack of a better term, they're trying to find out who is susceptible to being, preyed upon. So they are looking for victims.
What age group victims are they looking for?
Each person is different, but given that since there are nature of investigation involve children, it's anybody under the age of 18, and anybody that's considered a child in the state of Nevada.
Counsel, before you go to the next question, can I have one counsel from each side please approach? We're going to turn on to white noise for a brief second, if you have time, please. Or two counsel, I don't care how many you have. Feel free to proceed.
Thank you, Your Honor. Let's see here. I believe we were discussing why perpetrators use certain meta platforms. You mentioned that they identify certain victims who may be under the age of 18. What else do these perpetrators then do on the meta platforms like Instagram and Facebook versus Instagram?
Instagram and Facebook, they're essentially building their profile. That's what's appealing to their victims on the front end, appealing, making themselves look, cool, or somebody they can relate to, or just somebody that doesn't come off as someone that's going to victimize them. So they, of course, post their profile and do different things like that, just like anybody else would, in those instances.
Okay. Then at some point in time, do they then take their contact to the private side, to the messaging side? Is that what you're saying?
In my experience with these,
Object is leading, Your Honor.
Sustained.
Does Messenger app somehow become involved in the conversation at some point in time?
in my experience, the most prolific way that these perpetrators are able to directly reach out to whoever that they're trying to talk to, victimize, however you want to phrase it, is through the messaging app, because that goes directly and associated with their profile, whether it's, Instagram or Facebook or whatever have you.
How does an investigation like this get its start?
Well, anything referred to the ICAC task force is received through a tip line. That's generally how it goes. Sometimes it may be a concerned citizen that, reports directly to our office, straight to us or straight to the other agencies that are participating. But the majority of those cyber tips come through NIMIC, who is alerted by other, various platforms. It could be Meta, it could be Yahoo, it could be Google, or whatever the case may be. But those reporting agencies are tasked with identifying and flagging material that may be potential abuse material, and then send it to NIMIC, and those NIMICs is essentially tasked with farming it out to whatever region of the country is tasked with investigating it.
Okay. As you participate yourself in these investigations, do you collect evidence?
I do.
And what is some of the evidence you might collect in these investigations?
Some of these may be stuff that I've obtained, through subpoenas. It could be taking screenshots of usernames. It could be getting email addresses, anything that we may find that may be of evidentiary value to our investigation. So anything identifying us and tying us to that particular suspect on whatever platform it may be at that time.
Would that include digital devices?
It would, essentially. At some point throughout the investigation, that is definitely something we would like to tackle.
When you receive digital devices through an investigation, what do you do with those?
We submit once we receive it, given that I am not trained or an expert in how to go through each phone, what we do, we submit it for a complete forensic analysis is what the next start would be. If we seize a phone after obtaining, legally the authorization through a search warrant, we would then submit it for a forensic analysis.
You said through a search warrant. Do you have to obtain a search warrant to search a phone?
I do.
And then you said you send those off. Those go to a different department or division within the office, or where do they go?
There's a few options, actually. So we have a partnership with Homeland Security Investigations where they provide their forensic services to us. We also have multiple forensic analysis, individuals who pull forensic analysis and run reports on phones for us in the ICAC task force itself. I believe there's 3 individuals that do that for us. So we do have quite a few options on how we want to proceed with it.
Is Mr. Defonseca one of those individuals within the office?
Correct, he is.
What do you usually get back from those forensic analysts?
Usually we get a report back with identifying information on IP address of the phone, any email associated to that phone when they registered. Essentially, it's a copy of your phone.
Do you get copies of messages that are on the Messenger app back sometimes from those phones?
Sometimes. Sometimes we do. Sometimes because of the end-to-end encryption, they're not viewable. So sometimes. Not all the time, but sometimes.
How do you proceed if you don't have the digital device, or if your agency isn't able to get a forensic analysis of the device?
That's when we will submit our legal processes through whatever provider or person that flagged the initial tip to us. We will reach out to them and start an investigation electronically there. So we would go submit a preservation request for whoever that may be, and then of course go through the, investigative process, you could say. So we reach out to that provider directly.
You said legal process earlier. Does that mean a search warrant?
Not right away. We have to go, it would be a subpoena, different stuff to build up so that we can establish to a judge that we have probable cause, and then we get authorization from the judge to be able to submit that to the provider.
Okay. But once you have that built up, then you're talking about a search warrant.
Specifically not for the phone yet, because we haven't got there, or if we don't have access to that phone, then yes, we'll go back to the provider and ask them for certain identifying information that would help us in this investigation.
Are you also going to ask for are you also going to ask for the contents of the messages?
That's correct. That's one of the things that it's always standard that we ask for in these types of investigations.
Okay. Have you served search warrants on Meta for content before?
Yes.
What's the process you have to go through in order to serve that search warrant on Meta?
You have to create I guess it's an account through the law enforcement, or you submit everything through the Facebook law enforcement portal, I believe, or it might just be Meta profile now at this point, but you submit it through there. You would attach any identifying information for the account. You submit the preservation request, and then of course you attach whatever legal correspondence you have that gives you authorization from the judge, and make sure within your request you have identified information, the account number, it could be a vanity ID, it could be an email address, something that's going to help whatever Meta identify the account that you're looking for, and then you submit your request, and then you wait.
How long do you wait?
It varies depending on how much information they're able to pull back, whether it's a dual account, old account. Typically, the average is between 14 and 30 days, depending on.
And that's just from the time you start preparing the legal process?
That is just the time that I submit
Okay.
when I'm submitting the search warrant.
Okay. What do you receive back from Meta?
It could be chat logs, it could be all of their likes, it could be account identifying information, it could be all the IP addresses that they're registered with that specific account. It just all depends whatever Meta is able to provide for us.
Okay. when an account is end-to-end encrypted, do you receive message contents back from Meta?
We do not.
Is that helpful to your investigation?
If we had the contents of the messages and we submitted the search warrant, that would be absolutely helpful to not only my investigators, but anybody investigating these kind of crimes, yes.
Would that be more helpful than the call logs and the other information you mentioned?
Yes, absolutely.
Why?
Because right there, when we get those correspondence back, in addition to whatever identifying information we have tying that person to that account, we have enough right there already to arrest them on site. That's the probable cause we would need to be able to effect an arrest immediately, rather than, kick, lack of a better term, kick the can down the road and further our investigation, where we would have everything right there we need to be able to effect an arrest.
So you said you don't get the contents of the messages from Meta. What does that mean in terms of your investigation when you don't get the contents?
It means that we're not only for this specific investigation, but if this person that we've identified that's part of a cyber tip, we've also are missing out on the opportunity to identify other potential victims within those contexts. So if, in my experience in these investigations, the perpetrators are not just looking at one or two or three, they're spreading the net as wide as they can, trying to victimize whoever they can, and it's not just specific to one person. So in these investigations, if we could get the contents of messages, we would also be able to identify potential victims. Other victims, I should say, additional victims.
Does it do anything to the length of time your investigation takes?
It does, it prolongs it. It does.
Do you have any idea how long it prolongs an investigation?
Each is different. So I would just say a safe guess for each investigation, at least 2 or 3 weeks, maybe a month, longer, depends on how much, where that specific investigation is at, how much information we already have, and how we're going to proceed forward. So it doesn't prolong it.
And I want to make sure I'm understanding this clearly. Is that on top of I think you said 14 to 30 days. Is it on top of the 14 to 30 days you said it would take you to get the information back from Meta?
Yes, that is after we have already submitted and we're past the waiting period. This is all after the fact, when we've gotten whatever return we've gotten from Meta or various other platforms.
In your experience with victims of these sorts of crimes, do they tend to make a lot of reports of these crimes, or do you find out about these crimes from other sources besides the victims?
Victims are really, really reluctant in these cases to come forward, and that's for a numerous amount of reasons, but typically the victims themselves aren't reporting the crimes.
What are some of the reasons? Again, we have to be brief, but what are some of the reasons why a victim might not want to report these crimes?
They're fearful that they did something wrong. They're fearful that they're the ones that are going to get in trouble. They've been groomed and told not to do so. They've been, they're functioning at a lower level than this adult, and they have become victimized at that point, and they have almost maybe they don't know how to, is what we found out through some of our investigations. So sometimes ignorance, they don't know how to report it.
You said grooming earlier. Could you explain to the court what grooming is?
Sure. I mean, it's essentially gaining someone's trust to, in these cases, they gain their trust, they kind of lull them to sleep, and then essentially bring out the victimization part of it. In these cases, a lot of what we see is that when the perpetrator is trying to groom them, they start out small, just compliments, real nice, just, texting, saying good things. The victim opens up a little bit, and that opens up the door a little bit more, and then it starts to gifts, maybe money. And they could even use what's called child sexual abuse material, also known, child pornography. It's an old, outdated term, of course, but now they can use that as like a, hey, look, it's okay, your secret's safe with me, you can send me a picture, you can do this and do that. And that's, CSAM is also used as part of, in the grooming process, or it can be, I should say.
Talk a little bit more about that. You said they're using that. How are they using that? What are they doing with that material?
So it could be that they're taking whatever, in my experience, a lot of these suspects, perpetrators, they have a collection of these kind of things. If they have it on their phone, and this is just in my experience in my investigation, what I've come across is that they will use this as kind of like a, hey, it's okay, I've done this before, I haven't got in trouble, you're not gonna get in trouble. Or they could do it on the flip side and say, you better keep sending me pictures, otherwise I'm gonna tell your parents and you're gonna get in real big trouble, when the victim doesn't know that actually they're the victim. So they use this almost like I like to use the term where they use it as the passcode to get into like the speakeasy, right? Like, hey, it's okay, I'm part of this club, it's okay.
Is that, that CSAM material transferred between individuals?
Yeah, typically, yes, it is, between individuals. Now, that may not be essentially an adult trading it with a child, but it could essentially be two adults consenting to it, but the material, the picture, the image, video, whatever it may be, that itself is illegal.
I want to talk a little bit about this time period that it takes you to get this investigation done. What could be happening during the intervening time period while you're trying to finish your investigation?
So if the account holder is alerted for whatever reason, we don't have a non-disclosure order or something that legally says, hey, please don't tell, whatever platform we're dealing with, please don't tell them that we're investigating this until the conclusion of the investigation. If we don't have that in place, the subject could be alerted to the nature of the investigation or alerted that there's law enforcement looking into this particular account holder, and they could potentially be destroying evidence. They could be, trying other methods to mask their past correspondence. It just depends, but typically they may get a new phone, they may destroy a new phone, try out various other means, maybe get some other VPNs or something to mask their identity.
Okay. What other things could be happening during the intervening time period besides the destruction of evidence you just mentioned?
The correspondence could still be happening between other victims, and they could be reaching out and trying other various means to contact other people, in addition to masking their efforts.
You mentioned that sometimes victims don't want to report. Is the grooming process a part of that?
It is. A lot of that grooming process is based on the establishment of trust within that relationship between the victim and the perpetrator, and a lot of that grooming goes into the secrecy of it, and excuse me, not telling parents, the word, they always tell them, don't say anything, or they try to keep it secret, and this is after they've acknowledged in those chats that, they are a certain age, or younger age, I should say.
So does that grooming lead to a lack of reporting to law enforcement?
Okay, leading, Your Honor.
Sustained.
What types of reports are have victims failed to make because of grooming?
Well, just basic reporting. If they're not reporting it, then obviously we would never know. So I guess it would be hard for me to say if what doesn't go reported if it doesn't get reported, but I know statistically, at least since I believe it was December, they have gone down, whether there's correlation or not. The tips coming from Metas through NITMIC have gone down since December, and that could be attributed to numerous amount of things, but they have gone down.
Speaking of those reports, do you know how many reports were made to the Southern Nevada Internet Crimes Against Child? Man, I can't talk today, I apologize. Were made to the Southern Nevada Internet Crimes Against Children Center last calendar year?
I do. I don't know the exact number. I know it's in the north of. I'm sorry. Let me clarify. Are we asking the total number or just
the total number?
Total number. It was north of 6,700, I believe.
Okay. And do you know how many of those were related to Meta?
Without having my declaration in front of me, I would say about 700, maybe somewhere in there, north of.
Okay. Wait, yeah, just a minute.
Oh, sure.
Thanks. No further questions for this witness, Your Honor.
Thank you. Cross-examination, Mr. Go ahead, please.
Thank you, Your Honor. Good afternoon, Mr. Gonzalez. My name is Timothy Hester. I represent Meta. Let me begin by saying, you said that you think perpetrators want encrypted messaging, right?
That's correct.
How do you know that?
In certain previous interviews, we asked them through means of communication, we have standard interview questions that we ask. And part of that is, why why did you choose this platform? Why did you do this? Why did you do that? Trying to get an idea of their motivation and behaviors to get a better handle on it. And they've said that they've used end-to-end encryption messaging apps. In addition to just, the messenger feature that we're talking about today, there's other apps out there that they use because it offers up an encryption, end-to-end encryption.
And what are the most commonly used encrypted messaging apps?
It could be the one we're talking about here, which is the Messenger app. It could be WhatsApp. It could be Kik. It could be some sort of Telegram app. So those, sometimes even just Apple messaging sometimes.
You know that iMessage is encrypted, correct?
Yes, I do.
And so when you said that that messaging is encrypted, Meta has not, over the past several years, has not been an encrypted messaging service, right?
Mhm.
And so you said you still
I need
see.
an audible, Council. Friendly reminder, need an audible answer, not ahas or ahas.
Oh, okay, I'm sorry about that.
Answers, go ahead, please.
So Messenger was not encrypted until December 2023, right?
Correct.
And in fact, it was just started to be rolled out in a default encrypted form starting in December 2023, right?
Okay.
Is that right? Do you know
Correct.
that?
Sure.
So what you're reporting on, the discussion you're having about what Messenger was doing for instance, in 2023, those were not encrypted messages, right?
So the messages that I'm referencing are when the encrypted feature is on and we pull something, we aren't able to see those specific messages.
So most of the messages that you've looked at on Messenger have not been encrypted, right?
I can't say that. I'm not comfortable saying that.
So you don't know.
I'm sure. I don't know.
Do you know what percentage of all messages on the internet are encrypted these days?
I do not.
You know it's more than half, right?
I don't know that.
You said that cyber tips come to you through NCMEC, right?
Yes, sir.
What is NCMEC?
It is the National Center for Exploited Missing Children.
And you said that NCMEC then farms out the cyber tips to different parts of the country, right?
Yes.
So NCMEC is the one that decides which parts of the country should get which particular tips, right?
Yes.
Meta doesn't make that decision, right?
No, and any other provider does not make that decision. They report it, and then NCMEC is in charge of farming it out.
Now, you described this pattern of abusive activity that you've seen involves in child exploitation. And you referred several times to whatever platform it may be on. You've seen this activity on a number of platforms, right?
Yes, sir.
So it's not just limited to Meta services, correct?
It is not.
And you said that you seized the phones. That's one of the first steps you tried to take, right?
Typically, no. Let me rephrase that. Whatever avenue presents to us, if we have enough probable cause to get a phone right away, then we will. If we have enough probable cause just to submit a search warrant to whatever provider that we're dealing with, we may do that. It's hard to say. There's not one approach to each investigation. They kind of vary.
And once you have the phone, you're able to read encrypted messages on the phone, correct?
Sometimes. Some of the forensic analysis that we've gotten have not been able to read encrypted messages. It'll show a log and there's some sort of correspondence there, but not every single time are we able to see.
So when you seize the contents of a phone, one of the things you're trying to do is review the encrypted messages, correct?
Correct. Yes.
And victims could also provide a phone which would allow you to review the encrypted messages, correct?
Correct.
You talked about victims not reporting crimes. You recall that?
I do.
You're talking about victims not reporting crimes to law enforcement, correct?
Correct. And not only law enforcement, but also maybe their parents, since we're talking about children.
But you don't know about victims reporting crimes or wrongdoing to Meta or other social media services, right? That's not something you do.
That is not me.
So when you were talking about reporting of crimes and victims' reluctance to report a crime, you're talking about reporting to law enforcement, correct?
That's correct.
And so there may be a different question as to whether victims are willing to report to Meta or other social media services, correct?
Correct.
You said that the reports from Meta have gone down since December 2023. Do you remember that?
I do.
And you said it could have been attributed to many things, correct?
Correct.
So you're not saying that you attribute that to encryption. You don't know that.
I don't know that for sure, no.
So there could be a lot of reasons the reports from Meta go up and down, right? They spike up and down.
Yes,
So you see this kind of variation and you don't know what causes it. You said there could be a number of factors that could cause it, correct?
yes.
You said that there were 6,700 reports made, within the past year to your unit, or what was that period of time?
So that was the year 2023, and that was just specific to the Southern Nevada area. So there's a Northern Nevada reporting area and a Southern Nevada.
And you said about 700 of them were attributable to Meta, right?
Yes,
So that means about 90% of them were attributable to other services, correct?
correct. I'm bad at math, so sure, if that's how the math breaks down, sure.
Well, we could do the math, but
Sure.
it would be, as a percentage of 6,700 total, you're saying about 700 are attributed to Meta.
Correct,
So that means the vast majority were attributed to other services, correct?
correct.
Now, you began your current role as a criminal investigator in February 2022, right?
Yes, sir.
So you've only been in the role for 2 years, right?
Sure.
And before that, you were a parole officer?
Yes, the juvenile parole officer.
And you're aware that Meta has offered end-to-end encryption as an option on the Messenger app since 2016?
Correct.
And so, based on your experience, I believe you said this before, what you saw is that people would use the optional feature of end-to-end encryption when they were using Messenger if they were engaged in the kind of activity you've described, right?
Yes, sir.
And so that impact on law enforcement that you're talking about has been in place since 2016, right?
Okay. Yes, sir.
So 8 years, right?
Once again, friendly reminder, you've got to have verbal answers, not
Sorry.
okay?
Yes.
Thanks.
So I've got it right. So this issue you're describing, the effect of encrypted messages on Messenger that you've been talking about, that's been happening to your understanding for the last 8 years.
Correct.
It's not a new thing.
It is not, no.
And we talked about some other messaging apps or messaging apps, sorry, that also use end-to-end encryption. Apple since 2011, right?
I'm not sure if that's, I don't know how long they've been, but sure, Apple does use encryption.
FaceTime since 2013, right?
I'm not sure.
But FaceTime is encrypted, right?
Correct.
Apple is encrypted, all of their messages.
Yes,
Signal is encrypted, right?
yes,
Google Message is encrypted, right? So you've got a lot of service providers that are providing encrypted messages, correct?
correct.
Not just Messenger.
Correct.
Nothing prevents a predator from making contact with a child through one social media service and then switching to others to keep up the contact, correct?
Nothing does prevent that, no.
So in other words, you could have a situation where if Messenger was not encrypted, somebody could decide to use an encrypted service to keep up the contact with the child, right?
Correct.
And in fact, that happens, right?
It does.
So you'll have predators who switch between services to achieve encryption, right?
Yes,
So even if Messenger is unencrypted, predators could still use other services for encrypted messages with children, right?
correct.
And in fact, that's what you see.
It does happen in investigation, yes.
Meta can provide other information aside from the contents of encrypted messages to law enforcement, correct?
They do.
And that includes, for instance, user reports, in other words, reports from users about bad activity.
Correct.
And you get that information, right?
Yes, sir.
It can also include a pattern of contacts that they're able to observe from the public elements of their services, right?
Yes.
It includes the date and time of messages sent. That's another piece of information that Meta can provide, right?
Correct.
And it can include contacts and efforts by predators to make contact with children on unencrypted services such as Facebook, right?
Correct.
And in fact, that's what you were describing before. You were saying that that's what you see, efforts by predators to make contact in public spaces with children and then take it to an encrypted message, right?
Correct.
And so Meta is able to identify that kind of activity, correct?
Yes,
And it does provide that to law enforcement, correct?
it does.
And Meta can also provide law enforcement with metadata about the communications that it sees, right?
They do,
Even if they're encrypted messages, it can provide the metadata.
yes.
And all of that is very useful to law enforcement, correct?
It's useful, sure.
You mentioned in your declaration, you said that it's a time-consuming forensic analysis to review encrypted messages on a device. You remember that?
I do.
You don't do that work. I think you said that. You don't copy, you don't engage in that forensic work to look at a device, correct?
I do not.
And that forensic work involves copying the contents of a mobile device onto another device, correct?
That's a crude way of putting it. I mean, that's what I said, but that's the only way I can, without training and expertise, that's how I can describe it best, is copying the phone.
It takes a few hours to copy a device, correct?
From my experience, it all varies. It could be days, weeks, it could be hours, depending on the amount of things. It could be storage, it could be whether or not it's password protected, if the system's able to break into the phone. There's a whole litany of factors that could impact that particular phone at that time.
But it could be actually much shorter than the 14 to 30 day period that you mentioned for getting other information, correct?
It could be, sure.
And often is, right?
I don't want to say often, but it can be, sure.
In your declaration, you have a statement that adults can use encrypted messaging to send CSAM without fear of being detected. Do you remember saying that in your declaration?
Yes.
It's not true, is it? There is a fear of being detected even if you're sending a message through an encrypted device, right?
I'm not sure, understanding the question. What do you mean?
Well, in other words, even if somebody is sending an encrypted message, there's risk that they're going to be caught, correct?
There's always a risk, sure.
And in fact, a lot of your work involves catching people who are sending messages through an encrypted form, right?
The tips originate from something getting flagged, yes,
Right.
and that's just the nature of what we do.
So predators are at risk of being detected even if they're sending messages in an encrypted form, right?
The encrypted, the reason that they feel comfortable using it, they think that it gives them a shield of an anonymous nature to what they're doing. So that's what, in the declaration, what I'm referencing is, and how they feel comfortable or fear of not getting caught. That's why they use the encrypted thing, as opposed to sending it via over email or something just like a regular, non-encrypted venue, I should say.
But in fact, they do get caught even though they're using encrypted messages, right?
They do get caught, yes.
Because of some of the things we've talked about, the ability to look at other activity of the predators, to look at the public activity that they engage in. There's a lot of ways you catch them, even if they're using an encrypted messaging form, right?
Yeah, they do get caught eventually, just not through the various traditional means, how like an email would be sent with CSAM material or something like that. So they do get caught.
Most of the time in your investigation, most of the time, you're dealing with encrypted messages, correct?
A good portion of them.
Because your point was predators want to use encrypted messages, right?
Correct.
So this is something you've been dealing with for years.
The problem is not going away, yes. It's been around for a while.
Child predators also use non-encrypted communications, correct?
Correct.
And so, for instance, in your declaration, you talk about Yahoo as an example, right?
Correct.
And Discord is another example.
Correct.
And you said that they report CSAM to you, CSAM being child sexual material.
Yes, sir.
They report CSAM to you, and so that tells us that predators are also using unencrypted messaging, correct?
That's correct.
How much of that do you see?
We see a lot of that too. Emails are a big one. Majority of them unencrypted come through via email.
So child predators are going to be using encrypted messages and unencrypted messages for this kind of activity, correct?
Correct.
And that's what you've seen.
Yep, that's correct.
So it's not as though encrypted messages is the way that you get this kind of abusive activity. You're going to get it on unencrypted and encrypted messages, correct?
We get them on both.
You said in your declaration, and we talked about this a minute ago, that victims often fail to report. You were only talking about reporting to law enforcement, right?
Objection, Your Honor, asked and answered.
I'm just setting the table, Your Honor, for just going to another line of question, but
I'm gonna overrule it and give short leeway to see what your next question is, to see if it's repetitive.
you said that victims often fail to report to law enforcement, correct?
To law enforcement, to family members, to anybody, making anybody outside of that particular conversation aware of what's going on. Could be friends, I mean, not formally reporting is not what, I don't mean formally reporting law enforcement, it's anybody, making anybody aware that's not in that conversation.
But you're not aware of how they report to social media services, that's not something you know?
No,
Have you done any research or empirical analysis on victim reporting?
I have not, no.
Have you done or reviewed any published research on victim reporting?
No.
Are you aware that Meta has programs in place to encourage victim reporting?
I am not aware of that, no.
Are you aware that victim reporting or user reporting increased by some 75% on Meta over the last year?
I'm not aware of that.
So we've talked about cyber tips a bit. Could you explain what a cyber tip is?
Sure, it could be just a basic report from a service provider, we'll say Yahoo, Meta, somebody, it gets, their system has identified something that could be considered abuse material to children, whether it be an image, it could be a phrase, it could be something, and they take that information, format it, and it could include identifying information, it could be maybe like an IP address or something, where that account originated from, and then that's what gets funneled to the task force.
And a cyber tip could be a lot of different things, right? It could be just an image that's being passed between two adults could lead to a cyber tip, right?
Yes, sir.
And a cyber tip could also be two adults sharing a meme or some joke between them, right? That could lead to a cyber tip.
If it has characteristics that could represent like harm to a child within that, yes, it could be.
So cyber tips don't always involve communications between bad actors and minors, correct?
No, it's not always directly adults and children.
And cyber tips don't always even involve, maybe I should stop. Let's define CSAM for the court so we're clear on that. How would you define CSAM?
Well, so CSAM stands for child sexual abuse material, or there's also CSAM, child sexual exploitative material. But in my own definition, without knowing the exact NRS on how it's defined, it's essentially what was known as child pornography, or it could be any naked image, video, anything that depicts a child in a sexual manner where they are under the age, under the age of 16.
So you could also have cyber tips that involve just suspected sharing of CSAM. They might not even be CSAM, right?
That's correct.
So a cyber tip by itself doesn't establish any wrongdoing. It's a tip, right?
It's essentially our tip into an investigation. So the cyber tip itself is not, it's a red flag, it's something to look into, but that does not, of course, that's not the end of it.
And in fact, you don't follow up on a lot of cyber tips, right?
There is a lot of cyber tips to follow up on, so there are some in the queue that have not been addressed yet.
So a cyber tip by itself doesn't tell you that there's actually any wrongdoing.
Until we follow up our investigation, it gives us an indication that there could be, but the tip alone does not say that something has occurred.
You don't know where, we talked about the 6,700 cyber tips that were received by your group in the last year. Do you know which platforms those came from, the ones that were not related to Meta?
I do not.
Some cyber tips came from platforms that did not have encrypted messaging, right?
Correct.
And some came from platforms that did, correct? And sitting here today, you don't know how many of those 6,700 cyber tips relate to communications on unencrypted platforms, right?
I do not.
Okay, those are all the questions I had, Your Honor. Thank you.
Appreciate things. Counsel for the state, are you doing the redirect?
Yes, Your Honor. Thank you.
Go ahead, please.
Good Investigator Gonzalez, thank you again for being here today. There was a lot of discussion from opposing counsel regarding the fact that encryption started on Messenger back in 2016. It wasn't default at that point in time, is that correct?
Correct.
So is the default portion of that new?
From my understanding, it's December is when it defaulted.
Okay. And so what does that mean, that end-to-end encryption is default on Messenger?
It means you download the app, sign up, the default setting on there is end-to-end encryption. I mean, that's just what you get when you sign up for it.
Okay. There's also a lot of discussion about other apps, iMessage, things like that. Is iMessage connected to a social media platform?
It is not.
Is Kik connected to a social media platform?
It is not.
Beyond Messenger, are you aware of any encrypted communication platforms that are connected to a social media platform?
I am not.
How does NCMEC determine where they refer a cyber tip?
There's something identifying that particular tip that comes in. They're the ones that identify where region it comes to. So that could be something in their IP address that flags in whatever state, for instance, it could be Nevada. It could be something tying the nexus to that particular area of interest, and that's how they determine how they farm it out.
Okay. Is Meta a law enforcement entity?
It is not.
When a predator meets a child on Facebook or Instagram, one of these other Meta applications, but then moves the conversation to something like Signal, how does the predator get the child to switch over to that other app outside of the Meta universe?
It's part of that grooming process and the trust process. So they will tell them, hey, let's switch to this. And I've seen it numerous times where they switch between whatever they're using before and then switch over to another app. So they have to give them their username and, just something almost like essentially a phone number, but at that point, it's different.
Do they do that on the original platform, or do they do it on Messenger, or do they do it, how do they do it? Where do they do that?
They do that in the direct messaging feature, the messaging app. They don't do that in a public setting where it's, they're not in the comments or, saying, hey, let's do this. It's always through the messaging feature.
Okay, do they give these victims their contact info on these other apps through Messenger?
In my experience from these investigations, what I've seen is that they don't give out anything identifying. So they're not going to say their actual number, their actual name, address, none of that stuff. They're going to give them another encrypted masking way to communicate with them, which is where they would give them a Signal or another encrypted messaging app.
Okay. Does encryption lower the risk of detection or prosecution for people who are involved in these sorts of crimes?
It does.
Object is leading, Your Honor.
The question I asked was open-ended, Your Honor. It could have been yes
Other
or no.
rules objection. Witness.
You can go ahead and answer that question.
It does.
In your experience, are teenage children likely to affirmatively select end-to-end encryption when it's not on by default?
No, and since we've talked with some of the victims and these things have come up, nobody has disclosed to us, now this is my experience, that they haven't disclosed that they wanted to also be a part of that in encryption or anything like that.
Have any of the cyber tips that we discussed so much led to the identification and prosecution of predators here in Nevada?
Some, yes.
And if these investigations took less time, would you be able to follow up on more of those cyber tips?
Yes, we would.
If I can have just 1 minute. Investigator Gonzalez, in your experience, do victims of these crimes always cooperate with your investigative efforts?
No, they do not.
Can you talk a little bit more about that?
Sure. It goes back to the reluctance to report to law enforcement. Sometimes parents or the victim aren't aware, obviously, that they're victims. So getting that specific device, or I think a consensual search, being able to look through that phone is not always a case. They're scared of being re-victimized. They just don't want to deal with it. There's a lot of trauma that goes into being a part of this investigation by nature. And that leads to them not cooperating or simply they just don't want anything to do with it. I've had some investigations where the parents just say, you're not gonna talk to my child, don't want anything to do with it, nothing happened, everything's fine.
In those situations, would you be able to secure the devices from those victims?
No.
From the parents of the victims?
Unless we go through means of somehow getting a search warrant again. But this, I was referencing a consensual kind of, surrender of the phone.
You'd have to get a search warrant against the victim.
Correct. And take their phone by force and seize it, so I have a lawful order to take your phone.
Is that something you want to do to a victim?
I do not, no.
Nothing further, Your Honor, thank you.
Thank you. Councilor Meta?
No further questions, Your Honor.
Okay. This witness excused for all purposes, for purposes of preliminary injunction hearing. Subject to recall or excused for all purposes?
Your Honor, we're fine with the excuse for all purposes for this hearing.
It would be for this hearing, Your Honor, right?
Right, I'm
Not for.
talking about today's preliminary injunction hearing. only.
Yes, Your Honor, we agree with that.
Okay. Witness excused, watch your step on the way down, thank you for your time.
Thank you, Your Honor.
Okay. Council, would you like to call your next witness?
Yes, Your Honor, the state would call Defonseca.
According to my court reporter, do you all want time so far where you're at? According to the court reporter?
That would be helpful.
It says 32 minutes for the state of Nevada and 20 minutes have been used by Meta, but realistically I have to subtract 5 minutes off the state because I called you on the bench for that quick disclosure.
Judge, I didn't start until direct examination.
Oh, never mind. I don't have to take away those. So it is 32. Thank you, Madam Court Reporter's on top of things as usual. Perfect, thank you. Go ahead. Thank you, Madam Clerk. Do it, mind sworn in the witness. Appreciate it.
You do solemnly swear or affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under pain and penalty of perjury? Can you have a seat? Please state and spell your name for the record.
It's Chris Defonseca, Defonseca.
Could you repeat that spelling? You kind of cut out a little bit. You could hear the background noise.
Yeah, it's Defonseca, Defonseca.
Appreciate it. Thank you so very much. Feel free to proceed, Counsel.
Thank you, Your Honor. Mr. Defonseca, thank you for coming today. Could you please explain to the court how you are employed?
I'm a digital forensic analyst with the Attorney General's Office, High-Tech Crimes Unit.
And how long have you been so employed?
This is my 22nd year.
And just very briefly, what sort of training have you received in order to hold that job?
I've been certified as a certified computer examiner by the International Society of Forensic Computer Examiners. Also certified as a Cellbrite, certified physical analyst, and a certified Cellbrite operator by Cellbrite Mobile Forensics.
Within the duties of your job, how much would you say you deal with child sexual exploitation, human trafficking, CSAM, those sorts of things?
About 50% of my cases involved CSAM.
Okay. Just very briefly, the other 50% of your cases, what are they involved?
Homicides, all types of white-collar fraud, that type of stuff.
Okay. Which jurisdictions and agencies do you provide services for?
Nye County Sheriff's Office, Lincoln County Sheriff's Office, Esmeralda County Sheriff's Office, Nevada State Police, Department of Corrections, and various agencies of the DPS, DMV.
You also provide services for the Attorney General's office as well?
I do.
Are you the only person with the Attorney General's office who does your job in the state?
There are two of us, one here in the south and the other one in northern Nevada.
Is that the way it's always been?
Yes, it has.
How do you get involved in one of these investigations regarding child sexual exploitation, human trafficking, and the like?
The investigators bring the electronic devices to me to be analyzed.
And what do you do with the devices? How do you analyze them?
First, in my role as a digital forensic analyst, my job is to image, process, analyze, and report my findings to the investigators in relation to the evidence that, potential evidence that might be contained within those electronic devices, such as cell phones and computers.
I believe you use the word image. Is that correct?
That's correct.
Could you tell us what you mean by the word image?
In relation to computers, it's a bit-for-bit exact copy of the hard drive, for instance. And on a cell phone, it's data extraction of the cell phone.
So when you image a device, when you copy or extract, what all do you collect?
Everything that's on a hard drive is extracted, and everything that the tool can extract from a cell phone is extracted.
Does that include all data from apps?
Pretty much most of the apps are extracted, except for smaller, newer apps which are not that popular, which may not be supported by the tool at that time.
Okay. Do your tools extract messages?
It does.
Do your tools extract pictures?
It does.
Do your tools extract metadata?
It does.
When you image a device, is there anything within the device or the material you image that is damaged by the imaging process?
No, there isn't.
What do you do with the device once you finish your imaging process?
We place the device back in the evidence vault, security the evidence vault, back in the evidence vault.
What do you do with the image of the device once you have that captured?
In relation to cell phone, the image is processed using a tool called Cellbrite physical analyzer, which processes and extracts all the data within the cell phone extraction and parses them out. That means organizes, categorizes the device, the data that was found into various categories such as pictures, videos, searched items, call logs, contacts, and such. And then after that, I use the same tool to create a report, which is called the Cellbrite Reader Report of the data extraction. And then I hand out the report to the investigator.
When you're doing this imaging and analysis of the device, do you have to have the passwords or the information to get into the applications on the phone?
Yes, we need to have the passcode to get into the phone to be able to be for us to image the cell phone.
Okay. What about individual applications on the phone that may have a password? Do you need those passwords as well?
If the tool cannot break those passcodes during the extraction, then we obviously need the passcode to get into those secure folders.
And I apologize, I think you said this already. Who gets the image of the device?
The image of the device is processed, and then a report is created from the device, and it's handed over to the investigator.
Do you ever, in your work and in your experience, have you ever run across devices that you could not get an image of?
Oh yeah, several of them. If they're locked, we can't get into them.
Okay. I'm sorry, but I want to make sure I heard what you said. You said if they're locked?
Correct. If there's a passcode, unknown passcode, then we can't get into them.
Are there other reasons why you might not be able to get into those devices?
Sometimes if the phone is damaged, then of course, we can't get into that device either.
Any other reasons?
Those are the two reasons that we are not able to get into a cell phone.
When you receive a device and find that you can't get into it for one of those reasons, what do you do then?
At that point, there's nothing that we can do.
What steps do you take then when you receive one of those devices?
If you get a device that's locked, we try our tools to try to get into them, but if the tool is unsuccessful, then at that point, there's nothing we can do, and we put the device back into the evidence court.
Do you tell the investigator that gave you the device about that?
Yes, we do. Yes, I do.
What does it mean when you say that a device is locked?
It means there's a passcode, an unknown passcode, which we are not aware of, which the suspect has not given up. So at that point, we can't get into it.
What percentage of devices would you say that you receive and look at are locked and you can't get into, conservatively speaking?
20 to 30%, sometimes even more.
Okay. Are you mentioned earlier about Cellbrite being able to break into those phones. Do you try to break those passcodes?
Oh yes, whenever we get a passcode protected cell phone, we first try to somehow get into it using the tools that we have. And sometimes we are successful, sometimes we are not.
You notice any trends with that?
It's especially difficult to get into iPhones.
Are passcodes getting harder?
They seem to be, because it used to be 4 digits, now it's a 6-digit passcodes, and those are pretty difficult to break into.
If there's an app on the phone that is end-to-end encrypted, can you get information out of it?
No, we cannot.
Why is that?
Well, I mean, the data is encrypted, so, I mean, without the key, there's no way that we can get it.
So would that be specifically in a device that, or excuse me, in an application that has a lock key to it?
Correct. If you can't get into the phone, then you can't access the app.
Let me restate my question. If you receive a phone that you can get into and an application on the phone is an end-to-end encrypted app, can you get into that app?
No, we cannot.
What has to happen if you can't get into an application that you need to get into?
There's nothing we can do at that point.
You said you handed it off to the investigator, is that correct?
That's good.
If you weren't having to deal with imaging all of these devices that had end-to-end encryption on them, would you have time to work on other investigations? You said you do about 50% other investigations. Would you have time to concentrate more on that sort of investigation?
Oh, yes, absolutely.
Are you have a minute, Your Honor?
Of course.
No further questions this time, Your Honor.
Thank you. Cross-examination, counsel?
Thank you, Your Honor. Mr. Defonseca, my name is Timothy Hester. I represent Meta. You know that Meta has offered an option of end-to-end encryption on Messenger for years, right?
Yes, I do.
Since 2016, correct?
I believe so.
And since 2016, you've seen circumstances where users do use the optional end-to-end encryption on Messenger, is that right?
Yes.
And so you and your team have been handling this issue of end-to-end messages on Messenger for about the past 8 years, correct?
Yes, I believe so.
And you indicated in your February 15, 2024 declaration that you routinely attempt to copy all applications on a device that you get your hands on, including any messaging applications with end-to-end encryption. All that?
Correct, yes, if you can get it in the phone, yes.
So if you can get into the phone, if you're able to get into the phone, you're able to review the encrypted messages on the phone, correct?
Yes, if you can get into the phone, yes, we can see all the messages.
So when you were saying before that you wouldn't be able to see the encrypted messages on a phone, that's only if you're unable to get into the phone, correct?
Correct.
So if you're able to unlock a phone and get into the phone, you can review the end-to-end encrypted messages on that phone, correct?
It depends on the app, yes, we should be able to.
And you said that about 20 to 30% of the devices you end up being asked to analyze are locked when you get them, correct?
That's correct.
And then how many of those devices are you able to unlock through your own techniques?
Very few.
You're also able to get a suspect or a victim to unlock the phone, correct?
Well, that's done by the investigator. If they are able to somehow get the passcode from the suspect, then they will. But most of the time, they are not able to get the passcode from the suspect because they don't want to cooperate.
But you're not involved in getting passwords from either suspect or victims in relation to
No, I'm not.
You're aware that there are other messaging apps that use encrypted, end-to-end encrypted messages, right?
Oh, yes, I do.
And that includes Apple's iMessage, correct?
Yes,
It includes FaceTime, correct?
I believe so.
Google Message also is encrypted end-to-end.
I believe so.
And what percentage of the messages that you're analyzing are actually end-to-end encrypted? Is it most?
I'm not really exactly sure. I don't really know the answer.
Do you know what percentage of messages on the internet are encrypted these days?
I'm not exactly sure.
You know it's more than half?
But I didn't know that.
How long does it take when you're provided a device by an investigator? How long does it take you to copy the contents of the device?
It depends on the size of the device. So if it's a large device that has a lot of storage on it, takes a much longer time. If not, it doesn't take that much long of a time.
When you say much, just give me the quantities. I mean, so for instance, at one end, you could copy a device in a couple of hours if it's not a large device.
Yeah, if it's a 1 terabit cell phone, iPhone for instance, it'll take almost a day or even more.
And then
For a 32 gig or 16 gig cell phone, it might take much less, probably an hour.
so between an hour and a day is roughly the range that you look at to copy a device.
Yes, pretty much.
And once you copy the device, then you have access to everything that's on that device, correct?
Yes, if we can access the device, everything that's on the device should be extracted. Depending on the tool, I mean, if the tool can extract what's on the phone at that particular time, using that version, it will extract everything, yes.
And that would include anything that's encrypted on the phone, correct?
Yes, since it's unlocked, it should be able to. If the tool can do it, it will. Sometimes the tools may not be able to do it, but sometimes it might be able to do it. Depends.
But in your experience, most of the time, once you're able to get into the device, you're able to review the encrypted messages, correct?
Most of the time, but there are some times that messages are not able to be read, even though the phone was unlocked.
Thank you, that's all the questions I have.
Redirect counsel?
Very briefly, Your Honor, thank you.
Good, please.
Mr. Defonseca, does end-to-end encryption make your job harder?
Oh, absolutely, it does.
I don't have further questions, Jim.
Okay. Recross counsel?
No further questions, Your Honor.
Okay, is this witness excused for purposes of preliminary injunction only?
Yes, Your Honor.
For the state, yes, Your Honor.
Appreciate it, thank you for your time, please watch your step on the way out. Okay, counsels, before you call your next witness, appreciate you all been going, and people might need an afternoon break. Would you like to take an afternoon break and come back at 3:35?
Thank you, Your Honor.
Okay, off the record then, thank you so much.